Well, hello. Hi, everyone. I'm Heather Moran, and I'm the CEO here at 6th and I. Whether you're here with us in person or watching virtually from home, on behalf of 6th and I and our valued partner, Politics and Prose, thank you for being with us tonight and for your support of a nonprofit and a local bookstore. By show of hands, how many of you are here for the first time? Welcome. It is so nice to have you. And for those of you who are new, let me tell you a little bit about this space. This building dates back to 1908. It was a synagogue for 45 years, and then home to an AME church for the next 50. When the church relocated and put the building up for sale in the 2000s, the highest bid was from someone who wanted to turn it into a nightclub. Now, there's no denying it would have made a pretty banging nightclub, but this sacred space was destined for something more. It was saved within 24 hours, and for the past 20 years, 6th and I has served as a center for arts, entertainment, ideas, and Jewish life. With this program, we now have the honor of hosting Justice Stephen Breyer 5 times, including once as a speaker for our high holiday services. Tonight's conversation is timed with the paperback release of Justice Breyer's most recent book, Reading the Constitution, Why I Chose Pragmatism, Not Textualism. The textualist philosophy of the current Supreme Court's supermajority says that the right way to interpret the Constitution and statutes is to examine the language as it was understood at the time the documents were written. This is not Justice Breyer's philosophy, nor has it been the traditional way to interpret the Constitution since the time of Chief Justice John Marshall, who served in the early 1800s. Marshall said that the Constitution must be a workable set of principles to be interpreted by subsequent generations. Informed by his 28 years on the court, Justice Breyer makes the case for a more pragmatic approach to the Constitution and examines the widespread and harmful consequences when a case is decided another way, like with the Dobbs decision, among others. Justice Breyer is a professor of administrative law and process at Harvard Law School, which he also attended. He was born in San Francisco. His mother's work focused on public service, and his father was a legal counsel for the San Francisco Board of Education for 40 years. It is also worth mentioning that Justice Breyer is an Eagle Scout. He will be in conversation this evening with Neal, Katyal, the former acting Solicitor General of the United States. He's a professor at Georgetown Law and a partner at Milbank. Neal has argued 52 cases before the Supreme Court, and after graduating from Yale Law School, he clerked for Justice Breyer. Thank you all again for joining us, and please help me give a warm 6th and I welcome to Justice Stephen Breyer and Neal Katyal.
What a privilege it is to be here on this night and with Justice Breyer. I had the privilege of clerking for Justice Breyer in the 1996-1997 term. I think it's fair to say no individual with whom I've ever worked has done more for me to restore my faith in the rule of law than you, Justice. You stand for humility, intelligence, wisdom, even-handedness, and every person who's watched you in that court, I think, shares these views. And I can just tell you on a personal note, now that I argue there without you, I miss you. For more reasons than one. But I do. And so thank you for being here. You've written this remarkable book, Reading the Constitution, Why I Chose Pragmatism, Not Textualism. And the way that we're going to have this conversation is that I want to ask some general questions about the book, get into a little bit, Justice, your philosophy of deciding cases, and then I have some great questions from the audience that they were kind enough to send in, and we'll get to those. But before doing that, the nation really suffered a tragic loss last week with the death of Justice David Souter. Remarkable individual. I actually was thinking about it that when I clerked for you, on my penultimate day of my clerkship, Justice Blackmun passed away, and there was the funeral, and Justice Souter eulogized him so humanely and powerfully, just saying, "Goodbye, pal," and telling some stories. What did Justice Souter mean to you, and could you reflect a little on his legacy?
Well, first I want to thank the 6 and 9. I want to thank the Prose and both you for inviting us. That's nice, and I also want to tell you, as he did, that he was one of my first clerks. So why is that important? Because everything I know really comes from Neal. That's it. But David, we always got, I don't know why, but people ask me the question, are you recognized? They used to ask that when you go out in the street in Washington. The answer is no, rarely. And so I would say sometimes, not very often, but when people recognize me, they always ask one question, always the same question. So, of course, that tempts the audience. They say, what question? So I say, the question they ask me is, aren't you Justice Souter?
The way I've heard that story, I've heard the story a different way,
What?
which is Justice Souter, when he'd drive up to his cabin in New Hampshire from D.C., he hated D.C., and so he'd go drive 10 hours, and he stopped at this rest stop in Massachusetts, and he gets out of the car, and there's a couple that stops him, and the man says, I know you. And the justice is very polite, says, "Sir, I don't believe we met. You're that fellow on the Supreme Court." "Indeed I am." "You're that fellow Breyer, Stephen Breyer." And the Justice Souter, who's very polite, doesn't want to embarrass the guy in front of his wife, says, changes the subject or something. And then they talk for a couple minutes, and then the justice says, "I've got to go, it's reaching nightfall." And so they part ways. And then the man turns around and says, "Well, what's the best thing about being on the Supreme Court?" And the justice says, "I'd have to say the best thing about being on the Supreme Court is the privilege of serving with David H. Souter."
That's true. There are quite a few of those stories, Sandra O'Connor's law clerks took him out to lunch, and they went into some of these stories. Then they asked him, one of them asked him, says, "Is it true that you and Justice Breyer are often mixed up?" They thought about that one first. Then they thought, maybe that's not so good. So he changed it. He said, I mean, is it true that you and Justice Breyer are often confused? And then they dropped it. Yeah, all right.
Okay.
But David was a good friend. He was a good friend. Miss him.
So maybe could you just tell the audience a little about what you do on the court? Your book begins just on the first couple of pages with the story about snails, which I think is probably helpful for folks to hear.
It's helpful for the groups. I like talking to the 7th grade, for example. And if you say, what in this book did you do? It's the snails. I mean, they like the snails. Okay, what? I'm reading a French newspaper, and it's about a lycée professor who's going, biology. He's going from Nantes to Paris, and he has a bunch of, in a basket, about 20 live snails. So the conductor comes up and looks. He says, "Do you have a ticket for the snails?" He says, "Ticket for the snails?" They read the fare book. It says no animals on the train unless they're in a basket, and there's a half-price ticket. Because they're not talking about snails. They're talking about dogs or cats or maybe a rabbit occasionally, but I mean, not snails. Is a snail an animal? See, this is a perfect story for 7th grade. Because in 7th grade, they're all looking out the window, you see. And then you talk to them about the story, and then suddenly all I have to say is I say, "Well, who's right?" And I don't have to say another word. Oh, they're talking for half an hour. Well, what about a mosquito? What about a caterpillar? What about a horsefly? I mean, please, don't be ridiculous. Aren't they animals? You see, there we are. Okay, now you know what we do on the Supreme Court. I mean, isn't that true? It may be in the statute, it may be in the Constitution. We have these words. The word, I have to admit, is not usually animal. It might be the freedom of speech, or it might be right to bear arms. But the point is, what does that word connect with? Where does it go? How much is within the, if it says policeman, does it include German policemen? Probably not. Does it include California? Depends on what. Depends on what. And you understand why I write this now. Because a lot of people, well, we'll get into that. But what we do, that's what we do. And we only take the cases, now I exaggerate a little because it's not quite only, but mostly, almost all, the cases where lower court judges have disagreed about the same legal question, which is usually what is the scope of this phrase or that phrase. And since they're perfectly good judges, we might hear 60 or 70 cases out of the 6 or 8,000 that we're requested to hear. Because you don't get all that often disagreement about what the same words apply to. But now you see what we do. And it could be about, it doesn't have to be about something that's going to end up in the Post or the Times. They pick out the ones that will get everybody excited. And there are some like that. But there are an awful lot not like that. I mean, we had a case, what was it? It was, does the comma in the Internal Revenue Code section something or other, which follows the word after the word for, mean that the next word is a which or a that. I liked that case. No one else did, but
Certainly not the fellow who argued it. So suppose you're talking to that seventh grader, and the seventh grader is pretty disaffected by the whole notion of law. She doesn't trust it. She doesn't trust judges. She thinks this is all theater, that you guys are all basically just coming to a result and just dressing it up with an interpretive philosophy. What do you say?
I say, no, that isn't what we do.
But
what?
Persuade her that isn't what you do. How often do you, for example...
Who would want to do that? Do you really want to do that with some kind of a thing like a comma after a word for in the Internal Revenue Code? I mean, if that's what you want to do, I guess, I don't know what profession you go into. Maybe tax law. But nonetheless, I mean, no, we don't do that. The cases are difficult, and you try to figure out what the better answer is as to the application of this phrase or that phrase or the freedom of speech, etc. And that's, some people think all you do is read the word. That's what Nino thought. We were good friends. We'd go and talk at, we'd like to talk to law school students or college students, and we did down in Lubbock at the football field. Mm-hmm. They must have thought there was a football game because there was a lot of people, there were a lot of kids there, and they end up thinking we're friends, that we like each other, Nino Scalia and I, but we have different points of view. Now, what was your question?
So trying to persuade that seventh grader that what you're doing isn't just seeking results. Not in the tax case.
Have you tried to persuade a seventh grader?
Never. Trust me. But not in the tax case. But I think the concern people have is when it's freedom of speech or the right to bear arms or those things. The text doesn't yield that much of an answer. Pragmatism may not necessarily yield an answer.
What you look to, there are more or less traditional ways. When I was in law school, I mean, the judges who had a lot of standing were Holmes and Cardozo and Brandeis and Learned Hand. And you can go back and find about the same thing if you ever read Montaigne on experience, 1584. And what he says is the way you ought to go about it, about the same way they went about it, and what the same way I try to. There are a lot of things you might look at. In the 18th century, one of my law clerks, who became a legal historian, she says that judges almost always asked, what's the mischief that Congress was trying to stop? Mm-hmm. What's the object here that they were after? What were the political arguments at that time in Congress so that one side or the other was trying to get a little edge here or a little edge there? What are the consequences if we decide it this way, or if we decide it that way? And how does that all match up with the values, the most important values perhaps for a government being in this document, the Constitution, but other values that we hold in America do have consequence and we want to see followed? So all those things. And how do you know? Is there a rule that says which is in which case? No. But all of us, after a certain amount of time, have experience, and that experience helps. Do you know whether you'll get the right result? No. But then what are you doing? You're trying. That's what you're doing. Like a doctor, like a lawyer, like any other profession. You're trying to use what you know and some of the things I just mentioned to figure out what is the better solution. Now, the reason I wrote this is because suddenly this wave has come along that all you do is look at the words. That's what Nino did used to say, and he wrote it down, too.
Right. So let's take Justice Scalia, your friend's, argument, which is, I don't want the judges to look at their experience. I don't want them to look at pragmatism. I don't want them to look at what Congress might have been thinking. I want to look at what the actual words are that Congress enacted, and anything else is the importation of a judge's views into what should be a more mechanistic approach to judging.
That's exactly right. That's just exactly what a real textualist, a tough one, and Scalia was, pretty much. I can't say 100%, but pretty much. So read the words. For one thing, it's simpler. Mm-hmm. For another, we'll get more uniform results across the country, and Congress will like it because they'll know what's going to happen. And as you said, it will keep those judges on the rails. It will keep them from substituting what they think is good for the law. To which I would think, when I write and what I say and what I'd say to him, those promises. Can you carry out those promises? Let's see, I'll take an easy case. An easy case. And I had to search for a really easy case. Where I said, we had a case, many of you know, that if you unfortunately have a child with a handicap, you can get the school district to provide special instruction. And if you don't like it, because you think that instruction isn't good enough, you can go into court. And if you win your court case, and these are the key words in that case, you get your costs. Your costs. So the woman in the case had all those circumstances, and she won the judgment, and it had cost her $29,000 for an educational expert, which she wanted. But the school board said that doesn't mean educational expert costs, it just means like lawyer's costs. Or it doesn't even mean that, it just means filing fees. Well, what does it mean? So I say, Nino, what does it mean? Oh, I get it. I'm supposed to look at the words. Okay, I'll do it. Costs. Oh, I see. Now I know, huh? Oh, I mean, I have to look at them really, really, really carefully. Okay. No, thanks. Costs. Oh, you mean I should look at it several times? Okay, I'll look at it several times. Costs. And now I have the answer, do I? No. I say it isn't maybe so easy as you are promising. Or you can sue the government, government officials for all kinds of things, and sometimes you win, and particularly if they commit a tort, but there are exceptions. You're certain ones you can't sue. And ones you can't sue are customs and excise officers. So we have a case because it really says you can't sue customs or excise officers or any other law enforcement officer. Does that include the traffic cop? Does it meet all the 100,000 policemen in these states? Would Congress have done that without even saying anything about it? Or does it just mean German policemen? Or who does it mean? Okay, let's look at those words. Now, you see, it's not so easy. But won't it stop us? Won't it stop us, the judges, who try to stop themselves, that's my experience, from substituting? Well, let's be completely because this is a tough question, and that's your first question that I haven't really answered yet, but
We'll come back.
I'll come back. Look, it's not so easy. I was born and grew up in San Francisco, as I said. I went to Lowell High School, public high school. My father worked for the school department. I went to Stanford. I've lived the life I've lived. So have all of us by the time we're 50 or so, and it's in different parts of the country, and we have different views in this country. My mother used to say that. She'd say, there's no view so crazy, there isn't somebody in this country who doesn't hold it. And then since we're in San Francisco, she'd say, then they all live in Los Angeles. But nonetheless, we're a country of 330 million people, many different views, and you can't quite escape your own skin. You can try, and people do try. They try to make this is the law, but law is not computer science, nor is it calculus or a branch of mathematics. But it isn't do what you want either. And so you're trying to figure this thing out while keeping your own private views private and not part of it. And that's been my experience. That's my experience for a long time, 40 years in the courts. And if you were there, you'd have a similar experience, but you might not be from San Francisco. You might be from Washington, D.C., and it might be that you have such... And I first thought, why doesn't everyone agree with me, who am so reasonable? And then I thought, it is a big country, 330 million people. It isn't the worst thing in the world to have people on the Supreme Court of different views. And I see sometimes, well, they don't agree with me. I think they should, but nonetheless, I can see it. All right, do you see? Oh, you want some proof? Proof of what? Of the effort, anyway, by the judges to keep their personal views of what's good out of it, unless they're in it, because maybe they're in this document or other places. Here, I'll give you an example. Let's look at what they said. Dobbs. Because I asked, you can ask Sam Alito, you can read what he wrote. I'd say, why did you overrule Roe versus Wade? I was in the dissent in that case. I thought the court should not have overturned Roe v. Wade. But I asked him, why? Did you vote to overturn Roe v. Wade because in writing Roe v. Wade, the court did not use textualism or originalism? He has to say no. The answer to that question has to be no. Why does it have to be no? Because before 2015, I guess, nobody ever used this textualism or originalism, whatever, in that way. And so every case would be up for overruling. And every time a client walked in your office and you said, you can't do that, that's against the law, he would say, well, let's ask him to change it. He's not going to say no. That's not the reason. Well, what is the reason you overturned Roe v. Wade? This is what I said in the opinion. It was egregiously wrong. So I say, now I see. You overturned it because you thought it was very wrong. But you have your whole system because you were afraid that I might think something is very wrong or very right. But you wouldn't think something is very wrong or very right. But you just did. And so isn't there a risk that you, the textualist, will in fact substitute what you think is right or wrong for the law? And why is the risk any less than the risk that I would do it? In fact, neither of us has the right to do it, and both of us must try not to do it. But there's no real difference between this textualism business and the originalism business. Oh, the originalism, that was good. That was the, you want me to continue?
Sure.
Right. That's the gun case. It's Clarence Thomas, who's a good friend.
Okay, before we get to the gun case, I want to stick with abortion for just another couple moments and just understand your jurisprudential philosophy here, because what you're talking about is the rule of stare decisis, the idea that courts should basically adhere to their prior decisions and not overturn them. In the book, you criticize Dobbs for overturning this key precedent of Roe versus Wade and Planned Parenthood versus Casey. And you say, in that direction lies chaos, I think is the words from your book. What do you mean by that, and how do you reconcile? There must have been times when you've overturned precedent. When
Of
you've
course.
sought to. So what's your test?
What do you want these tests for? This is not, I mean, go ask someone in any profession. Ask a musician. Learned hand compared very well, a rather lengthy essay, very good, to the job of interpreting texts, to the job of playing music that someone else wrote. And you are the interpreter, and you try to get it right. And what is that to get it right? Do you think there's a test to get it right? I'm not good enough at music, but I know some musicians. No, it's not that simple. And it's not that there's going to be a single test. Would I have voted to vote for Brown v. Board? I would have voted for Brown v. Board, and so would Sam Alito. And so would they all. Of course there will be cases that you have to overturn. And you can look to certain things and write down certain things that count as part of the test, and part of them is, have people relied on the old case? Part of them is, have you already departed from much of the old case in other things? And I have about 10 of them, or 6 anyway. But it's not mechanical. And people don't like that, if I say that. But it's true, you're neither making it up, nor is it purely mechanical. All right, so what is it? The word that Michael Boudin, who was a good friend of mine, he was a good judge too. He said, what is it you call a judge that you think is doing a good job? Do you say he is a brilliant judge? No. Brilliant is a word of praise that belongs to a professor. Do you say he is a hardworking judge? No. That's a word of praise that belongs to a lot of people, a lot of professions. What you say about the judge who does a good job, you say he's sound. And you can say the same thing about a lawyer. They're sound. Their opinions are sound. And what does that mean? Well, to me, it means it's helpful. It's helpful to the society in which we live. And that's what Hart and Sachs said when I was a law student. They said the object of law, in general, it's to help. It doesn't always, but its basic object is to help. In this country, 330 million people of every race, every religion, every point of view, etc. It is to help them live together more peacefully and more productively. And 50 years from now, if people read some of my opinions or yours or whatever you're writing as a lawyer or as a judge, and they think it was helpful, then maybe they'll say you were a sound lawyer, a sound judge. But that's the kind of thing we think of when we're thinking about a judge.
And I think if Justice Scalia were here, he would say, I don't disagree with that and soundness, but there's 9 of us. We're all sound, but we reach dissenting and concurring and sometimes majority results that are different from one another. We're not musicians interpreting music. We're interpreting a constitution with a democratic mandate behind it. So the stakes are different. You mess up the symphony, so what? Who cares?
No, it's not. Yeah.
But here you're doing something undemocratic. You're taking your own views and importing them into this process of interpretation.
I don't usually think I'm taking my own views, unless you mean by that I've read about 30 or 40 briefs that were filed on the case. I don't know why they call them brief. But regardless, and I've talked to my clerks, and I talked to all of them before, and we discuss it. And then having done that, my views are gradually beginning to form. I go into the oral argument. The oral argument is for the judges, not for the lawyers. If the lawyer has something new to say, why didn't he put it in the brief? But the oral argument is so that the judges can ask questions. And in my opinion, a good question is a question I do not know the answer to. I think the lawyer knows more about it than I do and may be able to answer this question in a way that will help me decide the case. Another good question is if I'm trying to show my colleagues where I'm coming from. A bad question is tell a joke. I can't say I've always resisted that, but that's a bad question because the lawyer it seems to favor will go, ha, 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 and the other lawyer will just frown. Don't do it. Don't do it. And to show that I know more about the subject than the lawyer, why? Why? I'm going to get to decide the case. They're not. There's no reason in the world I should do that. The oral argument is there for me to find some things out, if I can. And then you go into conference. And you'll discover, because we go around the table in the conference in reverse order, in order of seniority, the chief says, this case that we just heard on Tuesday was about da-da-da, the issue is da-da-da, and I think, and that takes about 5 to 10 minutes. And then it goes in order to Clarence Thomas, and went to me, and then to Sam Alito, and Sonia Sotomayor, and Elena Kagan, and Gorsuch, and Kavanaugh, and Amy, and now Ketanji Jackson. Okay? Then, no one speaks twice till everyone speaks once. A very good rule for a small group. Then after everyone has spoken twice, back and forth. Now, I learned over time, which most people should know pretty quickly, if when I say something in response to something that someone else said, if my point, and people are not stupid and they understand it very subtly and immediately, if my point is, well, I have a better argument than you, ha, 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 that will get me nowhere. Because all that leads to is the other person thinking, ha, I have a better argument than you, ha, ha, ha. He doesn't say it quite that way, nor do I, but they know, people know. So what works in that conference is listen. Listen to what people are saying and see if we can work with that, or how much can we work with that, or how much will they have to turn to what you've said, or to what someone else has said. Because the people in that room know perfectly well, they may pretend not to, and the newspapers certainly pretend not to, that what people are really interested in is not the Constitution according to Scalia, according to Breyer, according to Sandra O'Connor, anybody else. They're interested in what does the court think of it. So you're trying to reach a judgment for the court. Okay? And that may mean you don't get everything you want. And so you have to decide very often, how important is this to me, and to what extent do I reach out and say, okay, let's try it this way. And you try very hard. That's the only, Rehnquist, who was great Chief Justice, but he hated jokes in conference. And I only once was able to get a joke by. And then that's when I said to him, I said, Chief, I've discovered a way to get 5 votes on one opinion. And he said, how? Falling for it. I said, you start with 9. That's actually funny in the Supreme Court, but that's the only place.
So, Justice, let's talk about, I mean, when the case is really important, though, when it's not something that you feel you can compromise, like, I know how you felt about Dobbs. You know, it's in the book, it's elsewhere. You had that a few other times in your time on the court. You're deciding some of those important, momentous issues facing the country, the world. And sometimes your colleagues can be incredibly biting in their opinions about you, about what you've written. And you sitting in that conference room, and there you hear them say, I want to overturn Roe versus Wade, or whatever that you care passionately about. How do you just put that aside the next day? How does that work?
I was having lunch with Rehnquist once. There were 5 of us or 6 of us up in the lunchroom just after a conference. It wasn't Roe v. Wade, but it was something like that. And it had been 5-4. I mean, you don't always succeed at producing 9 people. But probably about 40% used to be unanimous. And the 5-4s were maybe 5%, maybe 15%, maybe 20%, but different 5-4s. But I said to him, you know, it's amazing. Here we are having a pleasant lunch, and it was fairly pleasant. And just 15 minutes ago, We were down in that conference room, and he said, I know. He said, I know, with half the court thinking the other half had lost their minds. Well, what you do, it's a professional job. I have never heard in that conference room a voice raised in anger in 40 years, 28 years on the Supreme Court. I have never heard one judge in that room say something rude or insulting, even as a joke, about another judge. It is a professional job, and it's done professionally. That doesn't mean that all the judges have to reach the same opinion, because, as I said, this is not computer science. This is life. It's human beings. We're trying to get results, maybe, that will help people get on better within huge limits, within limits of what is law, what is it in this case, what did they say in the conference report in the Congress. I'll look at that. I'm interested. Not everyone will. And you say, well, they write mean things about each other. Well, right over here, not very far, Nino and I, we like to talk together. And we were talking to a group of students, and one asked, well, how do you deal with the fact that why do you write mean things about your colleagues? So I know they mean Nino. So before Nino could answer, I say, you mean to ask my colleague, Justice Scalia, but I'm going to answer. And I'll tell you the answer. The answer is this. Some people suffer from a disease, and the disease is called good writer's disease. And if you are a good writer, and you come across a felicitous phrase, you can no more give up that phrase than a good comedian can give up a good joke. A good comedian, the earth could collapse. He could lose his job. He could lose everything. He'll tell the joke. And a good writer who finds the phrase will do something similar. And I know that with Nino, because I had that experience of going in and saying, don't put this in, please, Nino. I mean, it's not going to help anybody, and it's not going to help you. Oh, there it is. It's going to whoop you. And I say, we know that, and we don't take when he insults us directly. We don't take it seriously. He's trying to make some kind of a point, and we try to figure out what the point is.
Yeah, but you did practice what you preach. I mean, I remember when I clerked, and Justice Scalia did write something mean in a draft, and we proposed something mean in response, and you said, hell no, that's not me. And, will not say another bad word about my colleague or his opinion. I wish we had a little more of that these days. I had rudely interrupted you about the gun control discussion that you wanted to have. So I don't know if you want to say anything about that.
Well, that was the case. The gun control cases, I've been in dissent. And there's a big historical argument. I mean, the majority says, well, it says a well-regulated militia being necessary to the security of a free state, comma, the right to keep and bear arms shall not be infringed. You see, there's a comma. And so that's separate, the right to keep and bear arms. And then the other side of the history says that isn't what this was about. This was about people who didn't want to ratify the Constitution for 15 different reasons, and one they gave was that Congress, under Article 2, can simply call up the state militias who have just won the Revolutionary War and disband them. And we don't want them to do that. So Madison sits there and thinks, I can solve that problem. And so he wrote the Second Amendment, and the Congress can't call them up and disband them. And that has nothing to do with anything that's contemporary. Okay? That was John Stevens. That was in the Heller case. All right, there was a disagreement about that. But in Brewer, which is a New York law, Clarence wrote, this is all going to be looking at history. So that's originalism. Originalism is used for the Constitution more than textualism because a lot of the Constitution's words are sort of vague. And originalism meant, according to Nino Scalia, anyway, that you go back to the history when they wrote this and see what those words would have meant to the people at the time. So that's what's written into Brewer. I said, I see. We go back and see what they meant in 200 years ago, 75, 76, 77, 8, all right, fine, let's do that. I had just been reading, I admit this, Sumption, who was an English judge, good English judge, on their Supreme Court, had retired, and he'd written 5 long volumes on the 100 Years' War. Now, if you're having trouble, I won't say trouble sleeping, but you can learn about the 100 Years' War minute by minute. So I had been reading that, and so I said, well, let's look at some of these weapons. What about a skill ladder? Is a halberd, what's that the origin of? And by the way, what about Asian fire that you throw over the wall to set the town on fire? And by the way, is that the origin of the artillery? Well, he didn't deal with that directly. But he said, well, we can figure out those things. And I, of course, believe, no, they can't. They have no idea. Judges are not historians. We'll get briefs in. That's called law office history. I'm sure you never do that.
Never.
But they never. But I'd say, we're not going to be able to figure this out. This isn't the way to do it. And my point was, in addition, they won't let me, if I follow their method, look at the consequences one way or the other, and the consequences of having all these guns around. I won't go into right now, but you can guess what they are. And I thought that was relevant, and the majority did not. All right? People do have different views. And I think, well, Nino and I, when we would discuss this, I would say, look, Nino, of course, these words in the Constitution cannot mean exactly what they meant 200 years ago. George Washington did not know about the internet. Yeah, but he just said, I knew that. And then he said, well, the problem, Stephen, with your approach, this is like the 2 campers. Do you know the 2 campers? One of the campers is putting on his running shoes. The other says, why are you doing that? There's a bear in the camp. You can't outrun a bear. He says, yeah, but I can outrun you. He said, Stephen, you have a system that's so complicated, you're the only one that can do it. And he really means I can't do it either. But he didn't say that. He said, you're the one who can do it. And I said, that may be. But you have a system that if we adopt it, we will have a constitution that no one wants. And who will be right in that? We'll know 50 years from now. We won't know. Eventually you'll know. Eventually. But I wanted to write this because I wanted the people, and I tried to bring up cases where there were 2 sides and where I was in the dissent. So I could say what the opposite argument was so people would have a chance of seeing how it was written, which means it's not me saying how it's written. It means that's how it was written, and that's how the textualists wanted it, and that's how the originalists wanted it. And I don't want, I'm writing this because I think it's having a lot of people picking up this textualism. And I don't think it's going to be great for the law, but I can't prove it. I can give them examples. And that's what I've tried to do here. You know, every law professor in the country thinks he knows more about the theory of textualism and originalism and whatever you want than I do, and they may be right. But I can say to them, it's not very polite, but I can say to them, you know, I've had some experience you haven't had. And that's what I am trying to put in here. I'm trying to put in here, what does it feel like? And that isn't feeling. It is following law. But following law in the sense that I learned where they talked about Hart and Sachs and Learned Hand in Central Park and Frankfurter and, you know, certain judges. And Holmes particularly. And
you said something a bit ago that I want to pull apart, which is there's 2 kinds of law you're talking about in your book. There's constitutional law and statutory law.
Right.
And they're very different because in the constitutional law, you're basically hearkening to a tradition, and the book's explicit, of Chief Justice Marshall in McCulloch versus Maryland. This idea that there's a pragmatism to the Constitution. We wouldn't want to have in 50 years a Constitution that nobody wants, obviously. So there's that side, but there's the statutory side we haven't talked about very much yet. So let's just spend a moment on that. And in particular, I want to ask you about this somewhat new doctrine, the major questions doctrine, which is getting a fair amount of play in discussions. Your court used it over the last several years to invalidate, for example, President Biden's student loan forgiveness program, saying if it's a major question, Congress has got to give expressly that authority to the president or the agencies to interpret it. It's used to strike down climate regulations and the like. Is that a version of pragmatism in a way? Is it a way of saying a reasonable legislator wouldn't have given this
Yes.
major decision?
Yes, it is. It's just not new. And I'm sorry, but I taught, it's very hard. It used to be very hard to get students to take the course I taught. It was called administrative law. Now, I liked it, but I don't know if everybody else did. Now they teach it in the first year. But I mean, the question that's not new. I mean, I don't want to say that sarcastically. I'll say it nicely. It's not new. But the place where you have often this problem. There's a statute. The agency does a thing. Some people don't like. Are you ready for administrative law? Okay. The agency does something. X. Call it X. There are a certain number of people who don't like X. So they bring a lawsuit, and one of the arguments they use is look at the statutes that gave this agency the power to do things. If you look at those statutes, you will see they did not give them the power to do X. And the other side will say, of course, they did give them the power to do X. Famous case. And Louis Jaffe, who wrote this in the 40s or the 50s, his treatise on administrative law has all these things. There are a lot of things. For example, Skidmore. No, forget Skidmore. I forgot Skidmore, so we're not going to discuss it. No, not Chevron. That came even later. The NLRB case. The one where is a newsboy an employee. The statute says employee. Okay? And they said a newsboy. So we only had newsboys. No women were allowed when I grew up. But is that an employee? They said yes, the NLRB. And should we give weight to that? Well, you look at the statute, and the court said, well, it's a pretty minor matter. It has to do with administration. They know a lot about things like that over at the NLRB, and they've been doing pretty well administering their agency. We'll give them some leeway. Arthur Goldberg told me that. It's the wrong word. The right word is leeway. Does the agency have leeway? Did Congress intend to give them leeway? Okay, then I said, let's go look at Packard. Same question, but Foreman. And the court, some thought it did give them the right to do it at the NLRB, put Foreman in as employees, others thought not. But nobody thought they get any leeway. Why not? Well, that was a case. Being a foreman was a big deal in the 1940s. And they thought Congress would not have wanted an agency to decide a question that important. And so this has a long history. And it is only one thing, call it the major questions doctrine, please spare me. The question is it the kind of issue that it seems likely in this statute Congress would have given this agency a little leeway when they did some interpretation? If, for example, it was something about X, and they gave the agency to the Attorney General, did the Attorney General know anything about X? No. No leeway. Is it the right agency? Is it communications? And they gave it to the FCC. You see? And there are 9,000 or 10,000 words in the statute books that are words like, general words, reasonable, or the equivalent. And probably that's a suggestion. That's where Chevron comes from. That's a suggestion Congress would have wanted to give leeway to this agency. And in that particular case, the Chief Justice and a majority wrote an opinion saying that Congress did not want to give the power, any leeway, to the EPA to decide a particular matter because it was too big a deal. If it's that big a deal, they'd want to keep it for themselves. And the dissent, which not surprisingly included me, said it isn't that big a deal. And they would want it to do it because the EPA has this job and they know a lot about it and they're experts. Now, do you see where it comes from? But they want to have a new thing saying, major questions, doctrine, with capitals. Actually, he did not write capitals. I just keep thinking he wrote capitals. But that's where that comes from, in my opinion.
So we are now in the audience question and answer period. The first question is from Ryan. What's your funniest memory of another justice with whom you served on the Supreme Court?
Each justice, the time that a new justice is appointed, and if you were the last justice appointed, it used to be that you had to have a dinner for him. And so we had a dinner for him. And it was Alito. And I was thinking of something, what would he find unusual? So already, you see, because I would have been the junior justice for the longest time in history. Joseph Story holds that record. It was something like 11 years. And I only needed 12 days. So I thought of writing to Alito and saying, could you please not be sworn in for 12 more days so that I can go down in history as the answer to a trivia question? Well, I didn't do that. Instead, for the dinner, I knew he was a great baseball fan. So we convinced the Philly fanatic to come to the dinner at dessert time. So the Philly fanatic walked into the room at dessert time, ran over to Alito, and sat in his lap.
Okay, this one is from Kami. You spent years interpreting laws. Did that ever spill over into your personal life, like debating if be there soon means 5 minutes or 30, or what is the true interpretation of an emoji?
M-O-G?
Emoji on your cell phone. It's a thing.
Well, I do have 3 children. We had 7 grandchildren. 3 of them have lived with us and their mother for quite a while. We say we live in the ruins of our house. But it is a great pleasure. And so what do you want to know? Does law help? I haven't tried it yet, but maybe it would help.
One question from Evan. What is deemed pragmatic for one person won't be pragmatic for others? When adopting pragmatism, how do you make sure it's objective and not overly favoring one party's view of pragmatism over the other?
The word pragmatism appears in this title as the choice of the publisher. I think the title that's actually better is that they did a French translation, which I was very pleased about. But it's called the Constitution des États-Unis, the Constitution of the United States. La lettre ou l'esprit, the letter or the spirit. And that's really what the book is about. And when you talk about the reason he got the idea, I didn't think it was a bad title, but it's American pragmatism. What is American pragmatism? There's a very good book about the club that they had in Philadelphia. What was it called? The Saturday Club? Menand wrote it. It was, Holmes used to go there, and the American pragmatists were Peirce, William James, Quine at Harvard. And what was interesting about American pragmatism is it recognized that in any person, there were all kinds of beliefs. There are all kinds of institutions. There are all kinds of scientific views. And they have to work out in a logical way inside the head of the relevant person. And so when you're interested in pragmatism as a judge, that does not mean just what you happen to think is the best thing. It means what you happen to think is the best thing maybe in a special sense, in the sense where after you consider, for example, stare decisis. For example, stare decisis doesn't mean never overrule a case. It means be very careful before you overrule a case. And look to see how the thing is working in that area. And look to see about consequences. And what are those consequences? And how do they affect other institutions? And you're never going to know all the answers. So you do your best to try to work to find as many answers as you can. And that's the part that I thought was, most relevant. And boy, I thought that was okay as a title, and nobody had thought of the French title anyway. And that's what it's doing there.
Justice, when you say look to consequences as part of pragmatism, there's a fear I think many have right now that the opinions of the Supreme Court may not be followed by the government.
It may not be what?
Will not be followed by the government, that there's some signaling of defiance going on. Is that an appropriate thing? I don't want you to opine on any particular case or anything, but is a pragmatic judge to look at whether or not a decision will be resisted by those who are tasked with implementing it?
You think I'm going to say never?
I'm not sure what you're going to say.
You're not? No one ever is, including my wife. the Frankfurter in the first miscegenation case. And when I was a law clerk, that's 10 years after Brown. And I came away and was working there thinking, the issue for this court is Brown and nothing else. And the issue is, how do we get Brown enforced? 10 years later. 10 years later. And how much did the government help? Not much. Eisenhower, though, did send the 101st Airborne into Little Rock. And things were coming along. But Frankfurter, the first time the miscegenation issue came up, said to the conference, which I read that anyway, he said to the conference, we can't take this case. Don't take it. Because if we take it, we're going to have to hold that a law that prevents miscegenation is unconstitutional. They have to allow interracial marriage. And once we do that, we will never get Brown enforced. So let's just not take it. Just what you said. And they didn't. And 3 or 4 years later, the second one came along, they took it and held just what I said. They said, of course you can't have a law that forbids miscegenation. But if you read the history of that, which I've read some books on that, Eisenhower said to Warren at a dinner, what the South is really afraid of is intermarriage, interracial marriage. And Warren took that as a sign that Eisenhower didn't want Brown. Well, reading enough of those, I don't think that's true. I think he did want Brown. He did desegregate the Army after Truman signed the thing, but Eisenhower really got the thing done. And he also desegregated the District of Columbia, from what I've read. And I think he was trying to warn them about something. And I think the thing he was trying to warn them about was what Frankfurter picked up. And the time of Arthur Goldberg, 1964, 10 years later. I said, well, what did it? Probably those troops helped. The 101st Airborne to Little Rock. The 9, some of us can remember those pictures of Elizabeth Eckford, black girl, one of the Little Rock 9, turning away from Central High School. And behind her is Hazel Bryant, white girl, her face what looked like contorted in rage at the thought of a black child coming into Central High. And Faubus, the governor, effectively said, they may have the court order, but I have the state militia. Off he went to see Eisenhower. Jimmy Burns, former Supreme Court justice, resigned to run the domestic effort in the war. It's supposed to be moderate. He said, if you send troops, you're going to have a second civil war, or maybe a second Reconstruction, or maybe they'll close all the schools. But Herbert Brownell said to Eisenhower, you have to. You have to. Rule of law. And he did. And everyone, I can remember that, the 101st Airborne, they were the ones that got hung up on the steeples in at the invasion of Normandy and were shot down. They were the heroes of the Bulge. And people knew that. They knew that in America. And so off they went. They took the children by the hand, went into the school, but they couldn't stay there forever. And when they left, that White Citizens Council school board closed the school. Well, what they did was they brought another case. They brought another case and said, it isn't working, integration. Well, it was working. This is a book. But regardless, they got to the Supreme Court. All 9 judges signed the order. That's rare. Integrate now. And the next day, Faubus closed the school. And no one was educated. And read the history of that. Read the history. Black and white students suffered a lot during that year. But, and I say in the book and elsewhere, who won? Did Faubus win? Hazel Bryant, did she win? Did they? No, they didn't win. But my view, why didn't they win? Why not? They didn't win because it was too late. That's my opinion, personally. I'm sure others can have others. Too late. That was the era Emmett Till's conference, coffin. Do we remember that being opened? Remember Selma? Do we remember Martin Luther King? Rosa Parks? The Freedom Riders? They had taken over. No, not taken over, but were leading towards a more awakened attitude of what was happening in the South in the rest of the country. Too late. They couldn't keep it closed. And the ones that the person I was trying to get, when I first told this story, I was talking to a woman who was the Chief Justice of Ghana. And she had asked me the question, why do people in the United States do what you say on the Supreme Court? And I said, I'm sorry, I have no answer. It's a custom. It takes time. Gradually, people build up to where it's sort of like the air. It's just something you do. And they don't think about it that much, but they do it. Even when, almost all the time, they may disagree, but they'll follow it. They will follow it. And so my point to her is, you want a rule of law? The people you have to convince, it's hard to believe that of our 330 million in this country, 329 million are not lawyers. Those are the ones that have to be convinced and understand why normally the right thing to do is follow law, even when you disagree with it. And I tell that to the students at Stanford, which I did. And I said, I know that 30 or 40% of you are thinking that too bad there weren't a few paving stones thrown. This was about Bush v. Gore. Too bad some of you are thinking there weren't a few riots, because I said there were no riots, which there weren't. But before you reach that conclusion about the rule of law, you turn on the television set and you look at how people get over and decide major differences in countries that don't have a rule of law. There's no absolute persuasive method. You can't say always, no matter what about Hitler and so forth, but you can say that's the norm. And you can give a few examples that will help people understand, who are not lawyers, why it is the norm and why people think. Why I think. I mean, my God, if people really didn't follow the courts, the Chief Justice said this, he said, you lose a case, I hate to tell you, half of them loses cases. And what do the people who lose the case think of the judge? They think he's an idiot. They don't say it, but they think it. The winning lawyer, what does he think of the judge? No, he doesn't think of the judge. He thinks he's a good lawyer. But the point is that losing lawyer appeals, and you appeal, and you appeal. That's all within the rule of law. So it would be unfortunate.
Last question, Justice. The Chief Justice Roberts, yesterday said that the rule of law is endangered right now. And just curious, are you optimistic about the future right now as you
Don't
look
know.
around?
The truth is, I don't know, of course. I'll tell you one thing that makes me a little more optimistic is because, as you can tell, I like to talk to school kids, and I like to talk to those in high school, and I'll even talk to my children's class when they're in the 7th grade, and it is true that they will be looking out the window. And now, more recently, they want to know, what can they do? What can they do to, what is this Constitution? And I say, I hate to tell you, this document is not my Constitution. It is now your Constitution, my friends. And you're the ones that will have to decide whether it works or not. And I can tell you, when I worked for Senator Kennedy, what he would say, I loved that job. It was a great job. Really fun, interesting. But he'd say, first of all, don't worry about the credit. I don't want my staff worrying about their credit. I mean, if the thing works, there'll be plenty of credit to go around. If it doesn't work, who wants the credit? But when you find that you're blocked because somebody doesn't want a law we want, or because they do want a law we don't want, here's what you do. You find someone on the staff of a different senator, perhaps, but who is intelligent. You believe that person is intelligent and doesn't agree with you. Okay, sit down and talk to them. No, don't talk too much. Listen. Listen to what they say, and many, many times, they'll eventually say something that you honestly agree with. And as soon as they say something that you honestly agree with, you then say, what a good idea you have. Let's see if we can't work with that. And quite a few times you'll get somewhere. Where? 30%? Take the 30%. Don't hold out for 100% where you don't get it and your followers say how brave you were. Forget about that. Get the thing. Get 30%. That's fine. And sometimes you will. And I saw him so many times when something did happen and the press says, oh, Senator Kennedy, you did so well getting that. And he would say, no, don't thank me, thank Orrin Hatch, the Republican. He came up with the idea that allowed us to reach an agreement here. Okay? Now, why am I optimistic? Not because of what I just said, but rather because when I'm saying what I just said, suddenly there are not so many looking out the window. That's why. Suddenly they're sitting down. Suddenly, I believe from the look in their eye, they're actually listening. And I believe that look says they're interested, we're interested, we want to know what to do, we don't want to just sit around and do nothing, and we'll listen to you too. And we want to know. And it's that. That's the thing. Younger, but they'll be older. Interested in helping this guy? Yeah. Okay, you see the point? And they're there. They're genuinely there. And when I think about that, I think I'm not so pessimistic as I might be.
I want to thank Sixth and I and Politics and Prose for putting this extraordinary discussion with Justice Breyer together. And I just, Justice, want to pull out one thing that you said. I don't know what I'm going to say next. I don't know what I'm going to say next. You know, when I argue cases before your court, particularly when Justice Kennedy was on and when you were on, I didn't know where you were, ever. Like, I had no idea, actually, how you were going to vote. We'd sit there and study it, but you'd sit there and listen. And that humility of just trying to not be so sure in your views and to listen to others and learn from them, I can't think of something this country needs more. And so thank you for your example, thank you for your service, and thank you for being here tonight.
Well, thank you. Thank you.
Thank you so much to Justice Stephen Breyer and Neal Katyal. Thank you all for joining us. If you could all just stay out of the aisles as our guests leave the sanctuary, we'd greatly appreciate it.